David Lemaire? Mr. Lemaire, you're gonna see that first group of chairs, go all the way down to the end. Second group. Yes, you can sit right there. Honor Jackson, you're gonna sit in that third chair, the chair. You Jackson? Okay, where's Miss Jackson?
Number 2 is gone, is a no-show.
Okay, okay, Walden, you're gonna sit in that third chair right there.
This one.
And, Jean Leonard, sit next to Mr. Walden. And you'll sit next to Miss Jean Leonard. And Ms. Sales, you're gonna sit next to Mr. Aguilera. Kennedy Moore, you're gonna sit next to Ms. Sales. Ms. Morse, you're gonna sit in that first chair. Mr. Sala, you're gonna sit next to Ms. Morse.
Yes, sir.
10 is not here. Tima Lopez. Mr. Tima Lopez, you got a chair in between you and Mr. Sala. Right there. The one with the yes. The one with the yellow and black tape. Mr. Hernandez, you're gonna sit next to Mr. Tima Lopez. Mr. Zapata, you're gonna sit next to Mr. Hernandez. Mr. Alvarado, you're gonna sit next to Mr. Zapata?
Here, sir?
Yes. Frederick Desertel, you're gonna sit at that second group of chairs, you're gonna walk all the way down to that end. Yes, walk straight down. And Ms. Cooper, you're gonna follow Mr. Desertel. He's gonna sit in the first chair, you will sit in the second chair. Keep going to the end. That's Ms. Cooper. Follow. Okay, Ms. Jackson. Okay, and Ms. Washington, you're gonna sit next to Ms. Jackson. Mr. Morales,
Yeah.
you're gonna sit next to Ms. Washington. Lady in the pink shirt.
Okay.
Mr. Davis, I'm doing fine, you're gonna sit next to Mr. Morales. Okay. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today to serve as a juror in a criminal case. It is a misdemeanor criminal case. Now, your criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as they're more serious type criminal offenses, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, if a person was convicted, if a person had a felony case, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. Now, the range of punishment for a state jail felony is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment, if they are convicted, is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, the case in this court, or the cases in this court, are misdemeanor cases. So you don't have to worry about those type punishment. Now, misdemeanor cases are divided into 3 categories. And we'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Class C misdemeanors are cases that start in the city court or the JP court, and they only come to this court when a person appealed the case, they appeal the conviction. And then that is, they get a new trial. In this court, the range of punishment is by fine only, and the fine cannot exceed $500. So they can't get jail time on a Class C misdemeanor. Class C misdemeanors, for example, if you're wondering what a Class C misdemeanor is, not wearing your seatbelt is a Class C misdemeanor. Speeding, Class C misdemeanor. Those type traffic offenses. Now, the next highest misdemeanor is a Class B misdemeanor. And the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or they could be given both such fine and confinement. Now, the case that we have today is classified as a Class A misdemeanor, and you have been called to serve as a jury or as a juror in this criminal case. Now, our courtroom hours vary, but they're normally from 9 a.m. to 5 p.m. However, in County Court at Law Number 2, we usually have large dockets. In fact, this morning at 9 a.m., we had 3 dockets. We had a trial docket, a pretrial conference docket, and an announcement docket. And when I use the term docket, what I'm talking about a list of cases that are in one of those 3 categories. And so we ended up, I think it was after 12 o'clock when we got out of court. So we normally start our cases, our trials at 1:30 in the afternoon. And we usually go from 1:30 to 5. And you'll be permitted to separate yourself during our breaks if we have a recess, or if you can separate yourself for lunch or in the evening at 5 p.m. Now, you'll be selected for inclusion on this criminal jury. In this case, will be tried expeditiously, consistent with justice, which require a careful and impartial consideration and a correct consideration of all the evidence in this trial. Now, I must administer to you the first of 2 oaths. Okay, so at this time, I need everyone to raise your right hand. And then once I finish administering the oath, please say, I do. Now, do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you or asked of you by the court or under its direction, touching your service and qualification as a juror, so help you God? Please say, I do.
I do.
Okay, you may put your hand down. Now, the law requires that each of you possess certain qualifications before you may be considered for jury service in this case. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on this criminal jury. It is very important that you answer all of the questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on the jury, the case could be retried. In essence, a mistrial can be declared, and the case would have to be retried, and then you may be held in contempt of court. That is, you can be placed in jail for up to 180 days, and you could be given a fine up to $500. Now, the first thing that I'm going to do, I'm going to ask a series of questions. I do not want you to answer those questions out aloud. Just simply answer those questions to yourself. Now, once I finish asking the series of questions, I will then ask you, is anyone disqualified under the law? So if you think that you may be disqualified under the law based on how you answered one or more of those questions, then I would ask you to raise your hand. And then once I ask you to raise your hand, if there's more than one person, we will call you up before the bench. This is the bench right here, one at a time. And then we'll discuss the matter more privately. And when I use the term more privately, what I'm talking about is, one, we're currently airing on YouTube because all trials and proceedings shall be public in Texas. And so we will turn the YouTube off. Then we will turn the microphone off. And then I have a noise device that sounds like this. And we would discuss, and then we would ask you to come up before the bench. And then you'll have to come on this side of the bench because there's a microphone to my left. The microphone is for the court reporter who is sitting to my left. She is dictating or typing down everything that's being said. And so you're speaking to the microphone, okay? Now, again, I'm going to ask a series of questions. Please answer those questions to yourself. And then at the end, I'm going to ask, is anyone disqualified under the law? If you think that you may be disqualified under the law, I ask you to raise your right hand. First question. Except for failure to register, are you a qualified voter in this county and this state under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, this next question, I stop and I pause and explain to the jurors that by law, I'm required to ask this question. I'm not trying to pry into your personal affairs. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? And the last question is, have you served as a petty juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? Now, is anyone disqualified under the law? If you think you may be disqualified, please raise your right hand. Okay. Let the record reflect that no one on the panel raised their hand. So at this point, all of the jurors are qualified. Now I will move to exemptions. I will determine if any one of you who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just remain seated. I will ask these questions in the same manner that I asked the previous questions. That is, I will ask a series of questions. And then at the end, I will ask if there's anyone who will be claiming an exemption. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12 years and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the state, of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in Jefferson County during the previous 3 years preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States military forces serving on active duty and deployed to a location away from Jefferson County? Now, is there anyone on the panel who will be claiming an exemption? Please raise your right hand. Let the record reflect that no one is raising their right hand, no one is claiming an exemption. Now, I will proceed to excuses. Now, with the excuses, I will not be asking a series of questions. I will make 3 statements. And once I finish making the 3 statements, I'll ask if there's anyone who will be claiming an excuse based on those 3 statements. First statement, a juror may be excused for observance of a religious holiday upon the completing of an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the defense and without the consent of the state. Final question, or the final statement. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who will be claiming an excuse? Let the record reflect that no one raised their hand. So at this point, all the members of the panel are qualified. All the members, no members on the panel is claiming an excuse or an exemption. Now, ladies and gentlemen, before we get started, I need to explain to you that in this case, we have a pro se defendant. Pro se means the person have waived their right to an attorney and they are representing themselves. Okay. And of the abundance of caution, the court has appointed what we call a standby attorney if the defendant would like to get any explanation or any advice from the standby attorney, then the attorney is here to help in that regards. Now, in this case, let the record reflect that the time now is 2:20 p.m. on today's date of August 18, 2025. The court is in session in the case that is styled the state of Texas versus Chase Kimball. The defendant, Mr. Kimball, is sitting at the counsel table before you. And the standby attorney, Ms. Lori Ferrazzo, she's sitting to the right of the defense table. The state is represented in this case by attorney Haley Simmons. She's sitting first chair. And sitting second chair is attorney Shane Hilton.
Good afternoon.
Now we have some individuals in the jury box. They are two are interns. We have two interns, and then we have attorney Hubel, attorney Andrew Hubel. He's assistant prosecutor as well. And we have a defense attorney here regarding another case. Now, the court reporter in this case is Miss Ada Christie. She's sitting to my left. So she will be taking down everything being said. So speak up when you are answering or asking questions. The bailiff in this case is Miss Malbrough, and I think you have already met Miss Mosby. They'll be alternating as bailiff in this case. The defendant in this case stands charged by information. Now, when I use the term information, I know if some people are familiar with felony cases, they have what is called an indictment. That's a charging instrument. In misdemeanor cases, we don't call it an indictment, we call it information. Okay, so in this case, Mr. Kimball is charged by information with the Class A misdemeanor offense of resisting arrest, search, or transportation. Now, as I mentioned to you earlier, the range of punishment for a Class A misdemeanor is minimum 0 days to maximum 365 days in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. The state and the defendant have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come before the bench, and then we will turn off the YouTube, we will turn up the microphone, and then we will put the noise sound device on so we can discuss the matter more privately. Is the state ready to proceed? Is the defense ready to proceed, Mr. Kimball?
Yes, sir.
Okay. The panel is yours, Ms. Simmons, and we'll give you 30 minutes, and I'll be keeping the time.
Good afternoon.
Good afternoon.
Who here has been in board diary before? Brings me my next question. Who's actually excited to be here today? Hold on, because hands raised, a lot of crowd. I guess I wasn't saying, yeah, that's fine. So we're gonna talk a little bit about why we're here. My name's Haley Simmons. I don't feel familiar to me, but does anybody know me? Silly question. Does anybody know my colleague here, Shane? Does anybody know the defendant, Mr. Kimball? Yeah, think about that one for a second. And does anybody know standby counsel, Miss Lori Ferrazzo? So, welcome to board ire. For the next couple hours, we'll be each other's new best friends. Board ire is a little conversational, so I'm gonna be asking questions. Like Judge said, if at any point in time it might sound like I'm counting or meddling, you wanna talk private, do that, just let me know. So just a little bit of information real quick. I talk fast. I try not to. If Ada gets mad at me every once in a while, if I'm talking too fast, just raise your hand. I'll slow down. Okay? I do wanna say, whenever I ask you a question, if you could just make sure you're speaking loud for the record. And also state your number, that way it can get out as well. So, I saw a couple eyes perk up when we said that there was a pro se defendant here. Was anybody a little shocked by that? Okay, who's here's been on a jury? Okay, during that jury, was the pro se defendant, was it someone representing themselves, or did they have an attorney? Attorney. I just wanna make sure, we wanna make sure this is a fair and just trial, we wanna do everything right. Would anybody unfairly prejudice the defendant for choosing to make the informed decision to represent himself? Will all be fair? Will anybody unfairly prejudice me for choosing to move forward with it? So we're all on good terms, okay? So like Judge said, we're here on a resisting. So obviously, when we're talking about resisting, there's gonna be elements sitting down. Now, the state has the burden. So if you're selected for this jury, these are all the points I'm gonna have to hit. Okay? So when we're looking at this, it's very small, guys. I'm sorry, I'm gonna read it out loud for you. A person commits an offense, that offense being resisting, if the person intentionally and unlawfully prevents or obstructs a person the defendant knew was a peace officer from effecting an arrest, search, or transport of the defendant by using force against the officer. It's a lot of words, right? So, I know. So this is my burden here. These are the elements. I'm gonna break them down a little smaller. Defendant, or about a certain date, in Jefferson County, did intentionally and unlawfully prevent or obstruct a person that the defendant knew to be a peace officer from effecting that arrest, search, or transport by using force. Now we're gonna break it down, and I'm gonna be asking y'all questions, and I'm sorry. I know, it's funny being an attorney. I personally don't like public speaking either, but y'all are gonna have to talk to me too, okay? Prevent. Who here can tell me what prevent means? I've got someone back here. What your number are you? 17. I'm gonna try to, Ms. Jackson? Okay, when I say prevent, what am I meaning?
To stop, but to not allow the party or person to proceed.
Okay, so if we're talking about resisting, we're preventing, who are we preventing? Who are we trying to stop?
The peace officer.
There we go. You're paying attention to the old. If I can hand out candy, I would, but I can't. That's perfect. So means to stop something, as you said, or keep it from occurring. I don't want to keep picking on Miss Jackson, though, so y'all keep speaking up with me. Obstruct. What does it mean to obstruct? Do you
It
remember?
means to interfere,
Interfere?
as close to the previous one, I guess instead of stopping, make it harder.
Okay, perfect. And it's Mr. Solid?
Yes,
Am I saying that
ma'am.
correctly?
Yes, ma'am.
Okay, good. Right on the nose. Means to make progress or activity difficult. So I am trying to actively stop an officer from either the search, transport, or whatever's happening during that resisting. We talked about those three elements there. We'll get more into that. So arrest, search, transport. What's an arrest? We've all heard it before, right? But when I ask you to put it into words, it's a little weird. You're raising your hand, you're gonna be the shining star today, Mr. Sala.
Detain, I guess.
Well, be careful with that word.
No, that's true. That becomes before the arrest, doesn't it?
You're doing good. I have to have you come up here with me. Oh, you're good. Taking a person into legal custody by law enforcement. See, you know where you're heading. Must have probable cause. Let me ask this question. Does a peace officer have to make the statement, you are under arrest, for an arrest to take place?
Yes.
You think so? Ah, you're number 3. You're my attorney, aren't you?
No, it does not
Okay,
tell you that you're under arrest. You can be under a legal arrest by having your freedom to move about restricted.
right. So if we know someone has been taken into legal custody, we can look at facts around to know if an arrest has been made, right? So everybody that says yes, you have to make the statement that you are under arrest. And y'all see why that's not correct. Does anyone still feel like an officer should have to make that statement? Turn number 4, you're looking at me. You have thoughts? It's okay. See, board hours fun, it means to speak the truth. There's no wrong answers here, I'm not gonna pick on you. Everybody has different opinions. Your number, is it 15?
Yeah.
Yeah, it's 15.
Okay, yeah, 13, 15. I'm back here counting too. Do you have a question?
Well, if he don't tell you you're under arrest, does that mean you can't walk away? Or, I mean, if he just come up to me and do his due diligence and don't ever say I'm under arrest, I'm gonna just, okay, well, I'm free to go. Or am I not free to go because I mean,
Let me ask you this. You gotta be careful with this terminology too. If you're looking at a case and you're looking at everything around you, why do you think we have resisting in place? Why do you think that offense is made? We want safety, right? Safety of the officers, the community. So when an officer is responding to something, and let's say maybe there's some urgency, and they're trying to effect an arrest, the facts are gonna show whether an arrest has been made. Do you think in every situation, if there's something urgent, the officer has to say, hey, before I do this, you're under arrest, okay, and then type in?
I'm in the streets and you're in the courtroom, so in here, yeah, but if I'm walking down the street and he just stopped me and started questioning me, and, okay, well, I don't have time for this.
Mr. Sala talked a little bit about detain, we're not gonna go in that, but there's different levels. You know, we have a detain, then we have an arrest, there's different levels.
No doubt.
We're gonna keep talking about it, but taking a person into legal custody, you're no longer free to go. Facts around it, I can't get into evidence right now, so I'm not going to.
Taking me into custody, I'm just on the arrest.
Right, if you're in legal custody at that point, you're placed under arrest. Is anybody confused on that?
Yes, actually, I know you said you didn't want to go into the term detainment. What is the difference between being under arrest and being detained?
Detainment means the officer is merely just conducting an investigation at that point.
Okay.
There hasn't been an arrest made, they are still free to go,
Got
okay? There's different levels, I know, you're right, I am in the courtroom and you know, some things happen on the streets. And that's what board hours is for, guys, I wanna make sure y'all all understand the law, gotta be on the same page. Do we all feel better about arrest right now?
Well, yeah.
You're straight laughing at me, Mr. Newman, do you feel better about it?
Well, do I feel better about the definition of the term? Sure. Do I feel better about this panel's ability to understand the difference between the two in actual practice out on the streets? No.
I have to agree with
And
that.
that's why people are there.
Right.
And that's the great thing, guys, that's why it's conversational, I want y'all to talk, and I want y'all to ask me questions. And there's a really funny thing, there's a lot of people that come and retire and they're very quiet. That's not the key to not getting selected, guys. There's a saying, the more you talk, the more likely you're to walk, okay? Don't happen, it's true. So let's keep going in. Search. An act of searching or investigation by law enforcement. Anybody have any trouble understanding what a search might be? What might you be searching?
Person or vehicle or any of the property.
Anybody confused by search? Turn number 1, I am gonna pick on you at some point, you're on the quiet, you just heard me say. What about transport, turn number 1? Exactly that, guys. An act or process of transporting individuals in custody by law enforcement personnel such as suspects, detainees, or inmates. Everybody understand what it means to get somebody from point A to point B? We're gonna keep going. Talk about your opinion, bless you, I'm sorry. What kind of physical actions are enough to be considered using force? Turn number 4, let's come to you. Does it,
I guess when you have to physically put your hands on someone.
okay. Everybody agree with that? Must be some physical aspect to it. And we gotta go back to, go ahead, Jennifer.
Physical contact. What level of physical contact is what I've had an issue with, the officer just has his hand on you. Aside from holding on to you, I would think if they're holding on to you, it would be more forceful than just from your and their hand on them. And I understand that could be intrusive as well, but no force is actually applied.
Then you don't have a reason to put your hands on them physically unless you are.
Well, keep in mind, we don't wanna jump the gun here. When you're resisting, keep in mind, we talked about those elements at the beginning. Using force against the peace officer, trying to prevent, trying to obstruct from the arrest, the search, or the transport. Those are three different things, so keep that in mind, they are separated. Can a defendant technically resist all three? Yes. But in this case, I only have to have you prove one of those. Everybody understand that? I'm gonna answer that question, my slides, come back to you, I've been hearing you making that, so. I'm gonna come back to that in some slides in the future, and I think we'll be able to clear that answer up for you, okay? Mr. Solly. What's on your mind?
Oh, nothing, I was just,
Processing,
Yeah.
right? It's a whole process. Use of force, what is considered, that's what we talked about. Attempting to flee, elude a police officer. Does anybody think that's resisting? You do? No, it's real small, guys, I'm reading it out for you. If I'm attempting to flee or elude a police officer, keep in mind those elements we talked about at the beginning. Right? I'm using force against the officer, am I doing that here?
no, using force to get away from the officer.
Different crime in and of itself, right? Okay, does anybody here thinks that does constitute resisting? No? Okay, good, we're on the same page. What if I'm threatening an officer with physical violence as he's trying to arrest me? I'm not fighting him, I'm just, hey. I'm threatening him,
That's a different crime.
good. Are we able to kind of start seeing like a difference in what we might be resisting? Struggling with the officer while being restrained, handcuffed, or placed in a patrol car. Am I resisting?
Yes.
Who agrees? Raise your hand, I'm proud. Is there anybody who thinks that's not resisting? And it's okay, like I said, no wrong answers. Number, I'm gonna get this, 17 is Jackson, right? What was that you said?
It's just not complying with what the peace officer is.
Right.
recommending, so.
Are you saying that in the terms of consisting in its entirety? Okay, well, you could be verbal and non-compliant, right? You don't have to fight somebody. So we wanna make sure we're keying in on that force against the officer, okay? Cause you can threaten an officer all day long to prevent them from resisting transport or arrest. That doesn't really need the elements I have before he does it. So complying, non-complying, true, but we wanna make sure we're getting that force aspect. Does everybody understand? Okay. Physically attacking an officer, trying to arrest that person.
Absolutely.
Especially support, no question.
It got easier as we got down there, didn't it? Does anybody have any questions when we're trying to, I guess, decipher what might be constituting the use of force? For number 14, you're quiet. How are you feeling over there?
Yeah.
Understanding everything?
Yeah.
Okay. Use of force. For number 5, I'm gonna help answer that question here, okay? Texas courts have determined that any amount of physical force is sufficient for purposes of resisting arrest. Does that help?
Yes.
Okay. Does anybody agree with that or not agree with that? I'm sorry. Does anybody not agree with that statement? Go
Is
for it.
that your question?
Yes, and it's your number 12, is it Hernandez?
Yes.
Yes, sir.
Because I'm seeing when they arrest people and they're not actually resisting, and the officer keeps saying, stop resisting, stop resisting. And I don't get that.
Okay.
And who are they gonna believe?
Case by case basis, okay? So when we come to trial, we're obviously putting together evidence, right? And this is evidence if you're selected as a jury, you're gonna be able to see. I'm not the trier of fact here, you are. That's why we have jury, you know, we want it fair, we want it impartial. If you're selected as a jury, you will make that determination in deliberation, okay? So I can't get into the facts with you, but if you're selected as a jury, you will see the evidence. Does everybody understand why I can't get into the facts? Okay. But they're good questions, they really are. I want to, promote y'all to keep asking them. This one, I'm gonna read this very loud, it's in caps for a reason. It is no defense to prosecution that the arrest or search was unlawful. Does everybody understand that statement?
Yes, I do.
Absolutely. If the arrest itself or the search was unlawful, what this is saying, resisting regardless the arrest, search, or transport is still unlawful. It is not a defense, or I'm sorry, it's still lawful, the arrest. It is not a defense that the search or the arrest itself was not lawful. Meaning if they still use that force against the officer, remember, we've got that element checklist. Keep thinking about that when we're talking. If all of that meets up, regardless of the arrest or search being unlawful, you can still have resisting take place. Mr. Sala, you're looking at me.
Yeah, that feels a little iffy to me.
I agree. 100%.
Yeah.
This is the law.
I get
understand.
that it's the law, but if a person, if the cop is unlawfully detaining them or unlawfully
Be
searching
careful
them.
with detainment,
Yeah,
okay?
yes, I know, unlawfully stopping to search. Then how can the person resisting them
Be wrong.
be wrong if they're being wronged themselves?
Let me give you an example. Let's say you're being called out to a scene. Let's say you showed up at your mechanic. There's everybody around you, there's a lot. Your mechanic's really mad, you haven't made the payment, you want your vehicle back, you're buying. You're just hanging out. Your mechanic's got a crowbar. Okay? So you hold it, he's irate, he's yelling at you, you're gonna give me my payment. How are you feeling right now as that customer?
Threatened.
Right. Would you want maybe law enforcement to come out and defuse the situation?
Possibly, if I couldn't do it myself.
Let's say he's still irate, even when the officers show up. How many officers do you want to show up even?
As many as are needed.
As many as needed. So you're feeling threatened. Might be a concern for your safety. The point of resisting is to make sure, or why we have a resisting offense, is to make sure we can keep the community safe. Officer safety, everybody safe. So if an officer comes to a scene and you're still threatened, got that crowbar. If he's not compliant when the officer's trying to defuse the situation, he won't even help with the investigation. You could see where there might be some steps there that an officer would have to intervene. Again, guys, I know it's hard to understand sometimes, but this is the law and this is what we have to abide by.
And intervene to make an arrest,
Or intervene just to defuse the situation even.
but don't you have to have probable cause for an arrest or a search?
You do have to
To
have
even
probable
get
cause.
there, so I mean, where is that all into this?
Well, let's say it depends. Well, if I'm doing that. If I'm threatening somebody, guys, this is completely different. There might be a separate charge there, right? You might have PC for a separate offense.
Like what?
Well, that one, if he's threatening you, you might have terroristic threat. You might have assault coming your way.
Well, I might have assault coming my way, but there's no probable cause that an assault has occurred yet.
The
There's
officer's
no
there in the
terroristic
presence.
threat I'm seeing of any element of that yet, so.
If he's threatening you, keep in mind, these are just scenarios. This isn't actually what's happening. What I'm getting at is it doesn't just have to be the resisting that creates that probable cause.
Well, here's where I'm coming from, just from a legal
Okay.
perspective, is if the arrest or search is unlawful because there's a lack of probable cause,
Mhm.
okay, on the part of the peace officer, then how does this come into play? Because this sounds like, wait, you have no probable cause to be stopping me and arresting me, and you're messing with me. You don't suspect me of any crime. You have no probable cause to suspect me of any crime. And now I'm gonna say, leave me alone. I'm walking. You're not gonna stop me because you can't stop me. The guy says, I'm the law. I'll do what I want. These people say you're threatening them. And now you're saying the guy's under arrest and he can't defend himself to go on about his way. I mean, this
So we-
sounds pretty fascist to
We
me.
have to, I understand this is the law though. Keep in mind, I'm only reiterating the law to you guys. Probable cause.
It's Texas.
That just seems a little murky, and even with
Yeah.
I know you gave just an example, but here's the thing, I'm not gonna get my car if I don't have money, so none of that's even.
We
So
don't know
I'm
what's happening.
for going, but that's neither here nor there. But if you call the police to the scene, again, you call the police, so now I'm asking for them to intervene. To me, this is not the same thing if you don't have a probable cause to stop me. And then I proceed to move on with my day, and then now you're arresting me because I'm like, hey, you're not gonna stop me. I'm not seeing how the two are correlated.
So we don't necessarily need probable cause to stop somebody, we need probable cause for an arrest.
Okay.
So, right, we don't need probable cause at the point where you're conducting an investigation. At the point in which the officer has showed up in this scenario, he sees a guy wielding a crowbar or something, or he sees agitation, threats are being made. There might be threats that constitute terroristic group there. At that point, and again, this is a case by case basis. So I'm creating a scenario for you, kind of help you understand. So let's say in this scenario, the officer does see terroristic threat. He's created the probable cause, he has probable cause, and he goes to effect the arrest of said person. And there's resisting.
You have 8 more minutes.
You understand?
I understand that scenario, just not that.
I've got to keep trucking, I understand. So show of hands here, who feels like they cannot follow this law? I know there's a lot of confusion as to it, and that's okay. But does anybody feel like if this is the case, they would not be able to follow that law? Can we all be fair and impartial when it comes to this? And we can all keep it in our back pocket if it's necessary? Okay. Great questions, guys. We've kind of talked about this, and I talk a lot, so I'm gonna keep having to skim through. I've got 8 minutes left. We have this law, we're concerned about police officer safety. We don't know how many people are gonna be there when an officer shows up. The suspect's safety. Even the accused, who wants to make sure they're safe. And the general public safety. So everybody understands why we have this law, right? What type of witnesses would you expect to see in resisting? Anybody? Who do you want to hear from on the stand?
About saying about
Witnesses, displays, witnesses?
I mean, you know, do I say this? Obviously, we would expect to see the cop who is making the accusation or resistance,
Right,
but also anybody else who was there at the time.
good. We want to see eyewitnesses, we want to see the police officers, we want to hear from possibly witnesses after the fact. We want to hear these things. What I say, what I ask, or what Mr. Hilton might ask, that is not evidence. What a witness says on the stand is evidence, right? So we want to hear from these people. We don't want to come here and not have a case to give you, we want to build a case for you, we want to be our burden. So police officers, I know that's who y'all want to hear from and resisting. How do we treat each kind of witness? They got to answer it very small. Exactly the same. I'm gonna move fast here.
If you need more time, the court give you a latitude,
Thank you, Judge. I appreciate that.
and we'll give Mr. Kimball the same amount of
Yes, sir,
latitude.
of course. So we treat every witness exactly the same. That means you get to determine their credibility. Okay, does everybody understand what I mean when I say determine their credibility? So if I place somebody in the stand, I'm gonna go ahead and put this all up. Whoever may take the stand, they're all gonna start with the exact level of credibility. Is there anybody here that would give an officer either less or more credibility when they take the stand? Would anybody start them down here? Everybody's gonna start them off equally, right? Police officers aren't special witnesses. Okay? They're not to be given extra weight. But they're human. They're people too. And we gotta understand mistakes do happen, just like there would be elsewhere. Does everybody understand? We're gonna keep that level of credibility the same. And then from there, you get to determine. You might go down on credibility, you might go up. But we want to start them at the same level. Can everybody do that? Okay. All right, fun questions here. We're gonna go down the line. Everybody gets to talk to me here. So, what are your feelings towards local law enforcement? We've got a scale here. I've got 1 at positive, 2 at somewhat positive, 3 at somewhat negative, or negative. Right, lock in your numbers now, okay? I'm gonna go down the line, I'm gonna start with juror number 1, where are we at? 2, juror number 3,
3,
juror number 4,
1,
juror number 5,
2,
juror number 6,
2,
juror number 7,
1,
juror number 8, juror number 9,
2,
juror number 11,
Two.
12, 13, 14, 15,
1,
16, 1, 17, 2, 18, 1, 19,
2.
and 20. There's a reason I'm not an engineer, guys, counting that high. Yes. Okay, so that's your perspective there, that's completely fine, like I said, no wrong answers here. I just want to get a good feel for everybody where we're at, okay? So moving on. What would you like to see in a resisting arrest, search, or transport trial? What do you want to see?
as far as evidence goes. Body cam footage if we can.
You want to see the resisting take place,
Yeah.
right?
Yeah.
Okay, anybody else?
on top of that, I would like to hear from our witnesses.
You want to hear from everybody. Like we said, that is, their testimony is absolutely evidence. Anything else? Pretty
any
much.
footage around the area.
Okay, if there is any, right?
Yes.
Yeah,
If we understand that sometimes there might not be, sometimes we only got what we got, right? Video recordings. CSI crime scene investigation, guys. Keep this on the back burner, okay? This isn't CSI, I don't know if y'all watch the shows, I think they're fun, sure, but they're not really supposed to be after the ball, okay? The attorney's laughing, he knows it's true, right? We all understand that? We wanna make sure we're keeping it with the law here, that you're learning today, okay? And if you're selected as a juror, the judge is gonna give you the charge that has all the law you need. Please don't go back and study your CSI books, the judge will give it to you. Okay? Reasonable doubt. So that's what, does anybody know what that means? Mr. Walden? Is there a definition for reasonable doubt?
I'm sure there is. I can't recite it.
You think I can give you one?
Think you can give
Do you
me?
think I can give you a
Sure. Should work some.
I'm so sorry, guys. Texas law says that I have to prove my case beyond reasonable doubt. There's no definition. Got you there, didn't I?
Yeah.
I know.
Well, if you've been married, you know, yeah.
So what does that mean? If I can't give you a definition, and I'm supposed to be my burden of beyond a reasonable doubt, let's kind of talk about it.
That if you don't meet your burden, then
What's gonna happen?
the person is not.
No, I can't see. You have to hold me to that standard.
Hmm.
I want you to. If I do not meet my burden beyond a reasonable doubt, you must acquit. If I do, you must find that the defendant is guilty. Okay? So it's not beyond all doubt. If it was, where would you be? If it was beyond all doubt, if you had no doubt as to your mind it happened, where would you be? I'm giving you a hint. Sitting right here. You'd be my witness. You were there. You saw it firsthand. You know what happened.
Yeah. Good point.
Because who pays for the crime happens? Who pays?
Chaos.
Sure. Hans is probably in suit, right? He's sure that. But who picks where the crime actually occurred? The suspect. Police officers would say, hey, go do this over here. The suspect makes that determination, right? So it's not beyond all doubt. We're given the evidence of what we're allowed to get. Not beyond a shadow of a doubt, again, CSI, put it on the back burner, guys. Not beyond an unreasonable doubt. Best way to explain it, I hate saying this, guys, you will know it when you see it. Everybody understand that? So if I can't give you a definition, and what that means is please do not check your common sense at the door. Bring it with you. Y'all are the trier facts here, veracity is your wrongness. I need you to use your common sense, look at the evidence, look at everything, and make a determination of beyond a reasonable doubt from there. Presumption of innocence. What does that mean? Who has it? Absolutely.
The defendant.
He has it. He's not guilty right here,
Absolutely. That's the way the system works.
not guilty. You gotta choose right now, whether you guilty or not guilty.
Not guilty.
I have to meet my burden. Remember what I said, hold me to that. I have to meet my burden. So I really wanna go into this because as you know, it's per se, so I really wanna talk about defendant's rights, okay? This jumps around, I don't know why, but the burden, nothing. I'm proving the case, I brought the case for me and Mr. Hilton, that is our job. Does he have any burden sitting right here?
No.
Absolutely not. Does anybody think he does? Tell me the truth. Need to know. Okay, all me. Right to discovery. All of the evidence, that's what that means. All the evidence I have, he has been entitled to it. He has the right to that discovery. He can look through that. Everybody understand that? Right to trial. That's why we're here. He has the right to bring his case to trial. The right not to testify. I really want to key in on this one, guys. The defendant does not have to testify. If he chooses not to, you are not to hold it against him. Is there anybody here that would hold it against him if he chose not to testify? Great answer, guys. Good. Right to any evidence that might be exculpatory to him. How much time do I have, Judge?
You passed
Okay.
it, just
Okay.
keep going.
Right to defenses. He's entitled to defenses, guys. Okay? So everybody understand we're here to ensure a just trial. Anybody have any questions for me on that? So if you're selected as a juror, I'm sorry, this is your job. Decide the facts, apply the facts, and follow the law. We talked a little bit about it here. But like I said, if you're selected, you'll get a charge. All the law will be contained in that. That's what you're bound by at any deliberation. Do we have any questions for me? So while we're here at this stage, does anyone feel like they cannot sit through this trial? Or maybe personal reasons, religious reasons? We're all good to go? This is my last time I need to really be conversational with y'all. So if you have any questions, it's your last chance. All right, thank you so much. And if you're selected as a juror, I'll be for me.
Okay,
Thank you, Judge.
okay, Ms. Simmons, you took 33 minutes, so. Mr. Kimball, you have 33 minutes. You may go to the podium.
Never done before. What would you do if you called the police and they like that for somebody shooting back your vehicle with a firearm? Think about that for a minute. And you constantly harassed by police department for years on end, which I can't prove that now because the bond and dropped my bond and all evidence perhaps. Watch the video, you'll see. That's all I got to say. Watch the video, you'll see the truth. I'm putting dollars in. I tried to use their lawyers, but they wouldn't do nothing for me. I'm done.
Okay. Now, ladies and gentlemen of the panel, we're gonna ask that you follow the bailiff outside. We may ask some of you to come back in for some follow-up questions. And so at this time, the court will be in recess. Will everyone please stand as the panel leave the courtroom? And you can go out either door, either way.
The long wrap.
That's a long day.
That's good.
That's right.
Jurors, as you come in, you can be seated. Make sure she has those letters. You have the letters. Black envelopes. Yeah, you may be seated. Jefferson County Court, Law number 2 is back in session. The court is in session in cause number 23 CCCR 2629, case of style of state of Texas versus Chase Kimball. Let the record reflect that Mr. Kimball is credited in court, and let the record reflect that attorney Laura Perazzo, the standby attorney, is also present in the courtroom. Let the record reflect that state is present with assistant district attorneys, attorney Haley Simmons, and attorney Shane Hilton, who is sitting secretary. Let the record also reflect that the jury or that the panel is now present and seated in the courtroom. State, are you ready to proceed?
Thanks, ready, Your Honor.
Mr. Kimball, are you ready to proceed?
Yes, sir.
Okay. Now, ladies and gentlemen of the panel, we have Ms. Trina Redmond, who is one of the court coordinators here in County Court Law number 2. She will be calling some names. And if your name is called, then we would like you to stand and go to the jury box, which is to my left, the area that I'm pointing, where the bailiff is standing. At this time, I'll now put you in the hands of Ms. Trina Redmond. Ms. Redmond?
David Paul Lemare.
David Paul Lemare. Mr. Lemare, would you please come to the jury box? There are some badges. You can take one of those badges and you can pin it on your shirt. Next.
Shantae Renee Jean Leonard.
Shantae Renee Jean Leonard. Ms. Leonard, you can take a badge. Countertop. Next.
Sebastian Aguilera.
Mr. Aguilera, please come forward. Next.
Diane Sales.
Ms. Sells, you can come forward.
Karen Diana Kennedy Moore.
Karen Diane Kennedy Moore. Next.
Peter Paul Sala.
Mr. Holly can get a badge. Next.
Akeem Annabelle Tima Lopez.
You can pin the badges on. Okay. Now, members of the jury, at this time, I must administer to you the second of the two oaths. I need each and every one of you to raise your right hand. And once I finish administering the oath, please say, I do. Do you and each of you do solemnly swear or affirm that in the case of the state of Texas against the state of Texas versus Chase Kimball in cause number 23 CCCR 2629, that you will a true verdict render according to the law and the evidence, so help you God? Please say I do. Okay, you may put your hand. Now, members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority, but it is the divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of witnesses and the weight to be given their testimony. You may believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses, or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony of document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can hear the discussion on the point of law. The reason for this, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her. The lawyers would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of the case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspapers or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. Now, the badges that you were given, you need to wear those badges at all times because those badges identify you as being a juror in this case. Now, ladies and gentlemen of the panel, those of you who were not selected to serve as a juror in this case, on behalf of the staff here in County Court at Law Number 2, and also on behalf of the citizens of Jefferson County, Texas, I'd like to thank you for taking your time to come here this afternoon. I know some of you may be disappointed that you didn't get an opportunity to serve on the jury, and some might think that they wasted your time, that we wasted your time. But I can assure you that we did not waste your time. Earlier, I mentioned to you that this morning we had 3 dockets. I told you we had an announcement docket, we had a pretrial conference docket, and a trial docket. And those cases that was on the trial docket, those was going to be, one of those cases was going to be set this afternoon for trial. And during this morning, some of those cases that was on the trial docket was disposed of. And the reason why they were disposed of is because sometimes individuals say they want to have a jury trial because they have a right to have a jury trial. And sometimes, the state will make an offer to settle the case. We call that a plea bargain offer. So they decide, some people say, well, you know what? I want a trial because the jury might not show up, or maybe the witnesses might not show up. But on days like today, when jurors show up and when witnesses show up, it is not uncommon for individuals to have a change of heart and say, you know what? That offer that the state made to me a few months ago, it looks pretty good right now. So the point that I'm trying to make is that your presence, by you even coming here today, helped us to dispose of or get cases off the docket. And so I'd like to thank you for your time and attention. So your time here today was not a waste of time. And by the way, I know that when you came to court this afternoon, you probably looked over the door and you saw County Court at Law Number 2, Judge Terrence L. Holmes, and you probably said to yourself, I'm in the right place. I'm in Judge Holmes' court. Well, no, this is not Judge Holmes' court. This is your court. I'm only a public servant serving the citizens of Jefferson County. Now, anytime that you're in the area of County Court at Law Number 2, you can come and have a seat in your courtroom. And you can sit in that area right there that you're sitting in. We call that the peanut gallery. But it does not mean you could bring peanuts in here and eat, because this is not the Texas Roadhouse. And so you can come and have a seat in your courtroom and just see what goes on in Jefferson County, Texas. And I would assure you that you will find that that is very interesting, that it will be very interesting. Now, before you leave, the bailiff have some letters that she's going to hand to each and every one of you. And before you leave, I usually give everyone a handshake. We still have COVID and some of those things in our community. So at this time, I would like to give, if everybody could put some eyes on me, I'd like to give everyone what I call an air handshake, okay? All right, and thanks for coming. The bailiff is going to give y'all some letters, and once you get the letters, you're free to go. And each and every one of you have a blessed day. And as I mentioned to you earlier, this case is airing on YouTube, and our hours on the case is it starts at 1:30. So we're going to reconvene on this case tomorrow that's correct, State? You're going to put your witnesses, okay. At 1:30 on tomorrow, you can watch it on YouTube, or you can come and have a seat in this courtroom and see what's going on in this particular case, okay? So at this time, you're free to go, and everyone have a blessed day. You're welcome. You're welcome. Okay. Now, ladies and gentlemen of the jury, the state is going to put on its case starting tomorrow at 1:30. We need everyone to be outside the courtroom at 1:30. And then when we get ready to start back, the bailiff is going to come get you and bring everybody in, and then we'll start. Now, tomorrow, just a little overview of what you're going to see. First, the state is going to read to you the charging instrument, which is the information, okay? Tell you what he's been charged with and the elements in that information. And then after that, the defendant is gonna make a plea. What I mean by that is he's gonna enter a plea of not guilty. Okay? After he does that, then the state and the defense will have an opportunity to make an opening statement. Okay? Basically, the opening statement is telling you what they expect the evidence to show. After the opening statement, then the state is gonna put on its first witness. All right, and that's what's gonna happen tomorrow. So at this time, you're free to go. You can take your badges home with you. Make sure that you wear them when you come to the courthouse on tomorrow. Everyone, please stand as the jury exit the courtroom. Court will be in recess, 1:30 tomorrow for trial.